So we end up from there moving into a case called Obergefell versus Hodges, which is at the end of a string of cases about gay marriage in the kind of 2010s era, which we're not. Well, no, we are out of that now. So Obergefell versus Hodges. There is a lot going on, right? Like the opinion that's online is, I think, 100, 200 pages of various opinions with 4 dissents, I think. Um, it's there's a lot going on, and for our purposes here, I think that there are moving pieces we don't need to pay attention to. But one line that I want you to pay attention to in terms of the jurisprudence is, on one hand, we've been thinking of these cases as privacy cases, right? These are about rights so fundamental that you cannot possibly have ordered liberty, is the phrase, without these rights being protected. And so rather than being thought of as a substantive right, they're thought of as a due process right? Part of the process due to you in any good functioning government is that they're not going to intrude onto your sex life. The part of the process due to you by any functioning government is that they're not going to get between you and your doctor. They're not going to get between you and your spouse. And that's one framework for these decisions. We've also talked about in our workplace discrimination unit and our governmental discrimination unit, we've talked about equal protection and the Equal Protection Clause of the Constitution as another source of law. So in Lawrence versus Texas, one critical feature that's different in the law about the law in Lawrence and the law in Bowers is the law in Lawrence only makes illegal homosexual sodomy, while Bowers, remember, criminalized all sodomy, all oral or anal sex. And so one thing that happened in Lawrence is 5 members of the court said, we think that this falls under our due process cases, we think Bowers got it wrong, and we think that if you look at what Griswold versus Connecticut really meant, that this case violates, or this statute violates a right that is guaranteed by the due process clause of the 14th Amendment. Now, on the other hand, and this comes back up in Obergefell, there's a concurrence by Justice O'Connor, who says, well, I think this is better conceived of as an Equal Protection Clause problem. And that is, this is a law, in some ways unlike the law in Bowers, that specifically targets this group of people that do not that do not have ordinary access to the political process, that we might think are the targets of prejudice, of stereotyping, of kind of mob mentality, and the Equal Protection Clause is this bulwark built to protect people from exactly this kind of violation of their rights. So there's this dual conception, right? On one hand, you can think of this as an Equal Protection Clause case, and Justice O'Connor did. On the other hand, you can think of this as a substantive due process case, and that's what Justice Kennedy did. Fast forward to Obergefell, and we don't really get an answer in Obergefell, but we get what one famous law professor has called this kind of double helix of these are intertwined principles, right? There is something about this that is kind of this fundamental right that just is inherent in personhood, that is inherent in any concept of ordered liberty. And on the other hand, these laws that are at issue, so for example, in the cases leading up to Obergefell, we were talking about things like the Defense of Marriage Act, which forbids certain rights to gay couples that were married as opposed to straight couples that were married. And that strain exists very much in Obergefell. In the one part of the case was about, you have these states that are willing to recognize marriages from other states that violate their law. So for example, I don't think this was in Obergefell itself, but it was in one of the companion cases. in Wisconsin, Wisconsin was willing to recognize first cousin marriages, even though those were illegal in Wisconsin, right? Wisconsin makes first cousin marriage illegal. But from other states that had first cousins married, Wisconsin would recognize those marriages and treat them as marriages for all Wisconsin law purposes. On the other hand, even though other states were conducting gay marriages, Wisconsin specifically singled out gay marriages as marriages that we will not recognize in the state of Wisconsin. And so there is this, are we treating this differently? And it looks like the answer in these cases is yes, very much. We are treating these differently, right? That's the equal protection clause part. On the other hand, we still have this, we have this whole line of cases saying like there's all this important marital privacy at issue, right? These are decisions that we believe we should be allocating and saving for the intimacy between partners. And there is a strain in Obergefell that is, well, what business does the state have as long as there is no legitimate interest? For example, in cousin marriages, there are externalities in terms of children, right? You might think that if cousins get married and have biological children, those children will have health problems, which is pretty well studied. Those children might have other social problems and problems that impose burdens on society. On the other hand, what is at stake in the Obergefell decision is and this is the harm principle thing, right? That, well, what externalities could these marriages possibly have that harm society in such a way that we need state intervention? And so at the end of Obergefell, we end up with the answer, we don't know exactly why we have this right, but there is this fundamental right to marriage. Everyone has it. And at the very least, it includes marrying somebody of whatever gender or sex you want to. And there are soaring passages in Anthony Kennedy's majority opinion discussing just the importance of marriage. And so I think the right place to close this discussion with a quick footnote that if you look at internal queer community conversations about litigation, about what the goals were, and the paper that I assigned for you, Marriage Will Never Set Us Free, there is a lot of question of whether this was the right move, right? Whether kind of this, look, queer people are capable of being these conforming people, and that's what's so great about it. As opposed to perhaps there is this patriarchal or poisonous or property-oriented strain to marriage that perhaps we should be more critical of, and we should not just seek to conform and adapt to it. But let me quickly pull up the passage, because I want to close with what I think is some gorgeous language. The nature of marriage is that through its enduring bond, two people together can find other freedoms, such as expression, intimacy, and spirituality. This is true for all persons, whatever their sexual orientation. There is dignity in the bond between two men or two women who seek to marry, and in their autonomy to make such profound choices. Marriage responds to the universal fear that a lonely person might call out only to find no one there. It offers the hope of companionship and understanding and assurance that while both still live, there will be someone to care for the other. While Lawrence confirmed a dimension of freedom that allows individuals to engage in intimate association without criminal liability, it does not follow that freedom stops there. Outlaw to outcast may be a step forward, but it does not achieve the full promise of liberty. Without recognition, stability, and predictability, marriage offers without the recognition, stability, and predictability marriage offers. Their children suffer the stigma of knowing their families are somehow lesser. And so with that, I will talk to all of you soon.